Madhya Pradesh High Court, in its order dated March 12, 2024, has observed that a wife can only be debarred from maintenance if she has been living in adultery at and around the time of filing a maintenance application under Section 125 CRPC. Justice Prakash Chandra Gupta of the Madhya Pradesh High Court Indore bench upheld a family court order that had awarded Rs 10,000 per month maintenance to the wife despite evidences of infidelity brought on record by the husband. So what was this case all about? The parties got married in March 2015 as per Hindu rites and rituals. The husband soon initiated a divorce petition on grounds of cruelty by wife, and in December 2016, a Coimbatore family court granted him an ex parte divorce under Section 13IA of the Hindu Marriage Act 1955. Now, during the pendency of the husband's divorce petition at the family court, the wife also initiated an application of maintenance under Section 125 of the CRPC. What were the allegations leveled by the wife? According to the wife, the petitioner husband started to harass her and was demanding Rs 10 lakhs as dowry. Upon non-fulfillment of these demands, he had started to physically assault her. She further alleged that the husband did not allow her to speak to her parents and often taunted her, calling her ugly. She also accused her husband of receiving messages and calls from other women, and when she objected to the same, he would harass her more. The wife informed court that she kept bearing all such cruelty only because she wanted to save her marriage, and she also alleged of being thrown out of a matrimonial home 1 year prior to filing the maintenance application. Since then, the wife claims to be living in a rented room, and the petitioner husband has not arranged anything for her. The respondent wife also brought on record that she was dependent totally on her father and had no source of income to maintain herself. Besides this, she also brought to the notice of the court that her husband was employed as a botanical scientist at the Botanical Survey of India, from where he was drawing a monthly salary of Rs 50,000. Therefore, she prayed to be given a monthly maintenance of Rs 25,000, that is 50% of her husband's salary per month as maintenance. Now, what were the defense and the submissions made by the husband? The husband, on the other hand, has denied all these allegations made by the wife in her application. He pleaded that he never demanded for any dowry, nor he harassed her or subjected her to any cruelty, as she has been claiming. The husband also accused his wife of leaving him voluntarily without any reasonable cause. It was pleaded that the wife was stubborn and had an insane nature who used to physically assault the husband, abuse him and his family members. The husband also leveled allegations of infidelity by his wife, accusing her of obscene talks with another man during odd hours at night on her mobile phone. He then informed court that his wife was having an extramarital affair and wanted to reside with her lover. And he also brought on record that after leaving his company, the wife was currently residing with a boyfriend in Bhopal, for which he even produced some photographs, but without the certification under the Indian Evidence Act 1872. With regards to his own income, the husband submitted that he was indeed posted as an assistant scientist at the Biological Survey of India, from where he receives a good sum of money and he possesses good character. He equally submitted that the wife was a qualified PhD and currently working, and therefore she was not entitled to any maintenance from him. Now, the family court in November 2022 noted that the husband was a government servant, and as per the calculations, they said he was earning up to around 69,000 per month. The court noted that the wife was unable to maintain herself and she had enough reasons for living apart from the husband. The court also said that since the husband had enough and sufficient means to provide for his estranged wife, they granted her Rs 10,000 per month as maintenance. The husband challenged this order in the Madhya Pradesh High Court. Now let us quickly understand what is subsection 4 of section 125 CRPC. This subsection reads as follows. No wife shall be entitled to receive an allowance from her husband under this section if she is living in adultery, or if without any sufficient reason she refused to live with her husband, or if they are living separately by mutual consent. Now let us understand what were the findings of the Madhya Pradesh High Court and what did the order say. Justice Prakash Chandra Gupta of the Madhya Pradesh High Court has now dismissed the husband's revision petition upholding the family court order that awarded maintenance to the wife. Justice Gupta said, according to CRPC, the term wife includes a woman who has been divorced by her husband and has not remarried. From analysis of the provision and the case laws, it is apparent that adultery under section 125(4) of CRPC has to be continuous and the liability to prove it is upon the husband in order to debar the wife from getting maintenance. Adding further, Justice Gupta said, the wife can be debarred from getting maintenance on grounds of adultery only when she is actually living in adultery at or around the time of filing the maintenance application. The Madhya Pradesh High Court subsequently concluded that the husband was unable to prove adultery charges and thus she was entitled to maintenance. So what is our take in this case? The matrimonial legal system in India is virtually a curse for men. The lopsided laws which were made decades ago favor only and only the women. And even if the law clearly states grounds for rejecting maintenance, there are enough loopholes in the law to challenge these grounds for rejection. There are multiple stages for fighting divorce battles for the men. In early stages, most men are geared up to get justice because every rational man believes in the system if they have been penalized without doing any wrong. The second stage of the matrimonial battle for the men comes after 3 to 5 years after they have dragged themselves to court and they realize it is better to pay off one-time alimony to their estranged wife and get rid of the torture at courts by paying hefty fees to the lawyers for years. The third stage comes nearly after 8 to 10 years where men lose all hope and start living their lives even if the cases fail to end. After the third stage, a mutual settlement is almost impossible since the demand from the wife is absolutely unrealistic and unreasonable, while the man who has lost his prime years of life is now on a kind of revenge mode for not shelling out a penny in alimony. To conclude, sadly, the system is set up for feeding lawyers from both sides, while the aggrieved party, that is the husband who goes to court for relief, ends up becoming a scapegoat. I am leaving the entire Madhya Pradesh High Court order in the description link of this particular video. Please go and read the matter in detail. Also, you can read other articles on voiceformenindia.com. Please do follow us on our social media handles, which is X, Instagram, Telegram, @voiceformenin. Please do subscribe and hit that bell icon so that you can be updated with all the latest videos as and how we broadcast them. Please do share these videos with your friends, families, relatives, colleagues for them to understand what are the ground realities at courts versus the social media chatter that we have, where we claim that women do not have equal rights in India. We'll return with new case studies and videos shortly. Thank you very much for watching. Namaste. Jai Hind.